I'm James Dapperchi, and this is Coffee and a Case Note. Today, guys, we're talking about Section 66G of the Conveyancing Act and trustees for sale. Pretty interesting area. What is a Section 66G trustee for sale? Well, it is the solution to a dispute between co-owners. What we're going to do today is work through some of the mechanics of what happens when co-owners of an asset can't get along. They got to sell it. So this, is the decision of Leasi and Fono. We got two owners of a piece of land. They enter into negotiations to sell it. The negotiations go nowhere, so the plaintiff decides, I'm going to have to commence proceedings to appoint a Section 66G trustee for sale. What the trustee does, come in, become the legal owner of the property, sell it, pay the expenses of sale, pay the trustee's expenses, of course, the trustee always gets paid, and then distribute the proceeds out to the beneficiary, to those co-owners. So the dispute ends, the asset gets sold, the money gets distributed. It's a pretty good mechanism if you have co-owners who can't get along. What happens in this case is the plaintiff commences the proceedings and there's a negotiation and the parties agree. They say, yeah, look, we can't really get along. Let's just get this trustee appointed. But they don't reach agreement on costs, right? So, to repeat, the overarching issue is done. They're going to get the trustee appointed. The trustee's going to go sell the property, get the money in, pay the expenses, distribute it out. But the parties between them don't agree on costs. The plaintiff says, you should have agreed to sale earlier on, and so I should get my costs from you on the indemnity basis. What the defendant says is, the biggest cost in these proceedings was your insulting and unreasonable affidavit that was irrelevant to the proceedings, and so each party should pay their own legal costs. The reason there's an argument is that the normal position is that the legal costs of both parties in a Section 66G application is that amount will be paid out of the trust funds. So neither party wants it paid out of the trust funds. What the judge does is firstly reflect on the plaintiff's suggestion that it was unreasonable for the defendant not to agree to those negotiations. And the judge says, no, the 66G application was fine. They couldn't agree. So the plaintiff is not going to get those indemnity costs. What the judge then does is consider the defendant's suggestion about each party bearing their own and says, yeah, look, the affidavit was long. There was some insulting elements. It basically dealt with the falling out between the parties. It was irrelevant to the application because the plaintiff wasn't seeking an adjustment to his entitlement from the sale proceeds. And so the judge said, on that basis, each party pays their own costs. Now, of course, the plaintiff's costs, which included that big, ugly affidavit, were much larger than the defendant's costs. So there was a trustee appointed to come in, sell the thing, pay the costs, distribute the money. There was a nice big bill from the lawyers, from the plaintiff, and probably a marginally smaller one and a bit of a smile on the face of the defendant. So I hope that illustrates the position when we've got warring co-owners appointing an independent trustee for sale and what might happen with the costs. And I hope you'll join me again next time for another coffee and another case note. Cheers.